live.
All right, welcome to the House Judiciary Committee. This Thursday morning, April 16th. We're returning to S-193, draft number 1.1. So this is just by way of introduction before I turn it over to Eric for a walkthrough. This amendment is based certainly in part on the testimony that we've received on the bill as passed in Senate, also in part on input from Jared Bianchi and Karen Barber. And I've been working with Eric and those folks as well to come up with something that we think is more straightforward and more defensible as far as with respect to the Constitution, kind of what this does. With that introduction, I'll turn it over to you, Eric, to walk us through.
Thank you, and good morning, everybody. Eric Fitzpatrick, how are you? With the Office of Legislative Counsel, here to walk the committee through a proposed amendment to S-193, an act relating to establishing a forensic facility for certain criminal justice involved persons. As the chair said, the primary big picture proposals that you're looking at in the amendment involve the competency to stand trial piece of the bill. Remember, because it involves both competency to stand trial and not guilty by reason of insanity. There are some changes to the NGRI piece, but the bulk of the changes by far are within the competency piece. And it's primarily to clarify the process and also to sort of in the background for a moment, the process of committing someone against their will, which is what's going on in the bill, is always subject to constitutional limitation, right? So there's always going to be some parameters around what can be done in statute. And the language that you're going to look at is an attempt to make the language in the competency to stand trial piece stronger in the event, I shouldn't say actually in the event, because one thing if I hadn't made this clear before, it's not a question of whether something like this, if it passes, might get challenged constitutionally. It will. You can be 100% certain of it. And that's because Vermont doesn't have a process like this currently. And aside from the fact that these sorts of systems are always challenged constitutionally when they're in place, you have an even additional factor in that Vermont doesn't have one yet. Like this would be new for our state. So not only whatever the Supreme Court has said with respect to the federal Constitution, challenges haven't been made under the Vermont Constitution for what this proposal would be. So you can expect that they would have it. So part of the goal here is to make the statute as strong as possible for the time when it comes that the sorts of cases are brought up. That makes sense? Big picture? All right. So that's the proposal. So what's the idea here? Well, the competency language as it came over from the Senate did have a bifurcation between someone gets, if you get sent to the forensic facility as a result of not being competent to stand trial, the general process was you get reevaluated every 6 months. So then at that 6 month period, you're found competent. Well, then the case gets sent back to the state's attorney and they can bring the criminal charges. If you're still not competent, well, then you stay back in the facility. You continue to get competency restoration services. The question was, well, what happens if the court finds that you're not restorable? Because what the Supreme Court has said in this sort of Jackson v. Indiana case, which is sort of the big picture United States Supreme Court case on holding people who are found incompetent, is you can't hold someone indefinitely absent a finding of dangerousness. So the processes that you see here are an attempt to create a system whereby the person won't be held indefinitely. And they have these periodic check-ins to determine because the court said, hey, you can hold them for as long as it takes to find out whether they're restorable or not. And this question of whether they're restorable becomes an important one because absent a finding of dangerousness, the person, I think constitutionally, has to have at least a roadmap for how they might get released if they're not dangerous anymore. So that's the idea. And so the way the proposal puts more detail on that is to say, I'll just describe it for a couple of seconds in the big picture because there's a lot of language here you get lost in. But it keeps this every 6 month part, right? So that was in the Senate. So person comes over, they're found incompetent to stand trial. They have to get an evaluation within the first 6 months, I believe it is. Or actually, yeah, within the first 6 months. And that period, if the person is found incompetent, they continue to receive restoration services at the facility and they get this evaluation every 6 months, right? Then at any time, at any one of those evaluations, those check-ins, anybody can ask for the issue of restorability to also be evaluated. Hey, is this person ever going to be restored? The idea is to try and not have someone held in perpetuity because there has to be an off-ramp. So that's through the restorability approach. And the question of restorability can be asked for at any time. If someone asks for that to be looked at, their evaluation has to specifically address restorability. And then the question becomes for the court, are they restorable or are they not? And if it finds that they are, yes, you're restorable, well, then that goes back to the forensic facility for continued treatment. Does that make sense?
Yes.
Because they're saying, oh, yeah, they can be restorable. So they might as well keep getting competency restoration treatment because the court's finding, yeah, they could be restored. Or the court could find, no, they're not restorable. Oh, this is a situation where it does not look like the person's restorable. That's the case. Next thing the court has to do is have a forensic risk assessment, because the question then becomes, oh, are they dangerous or not? You know, because remember, we said the person can't be held in perpetuity. So unless they're dangerous. So that's why you have this forensic risk assessment right then at that point. Decide, is the person dangerous or not? They get some testimony on that and they have this hearing within 60 days. And at that point, they have to decide, all right, is the person dangerous or not dangerous? Remember, these are only people who are not restored, right? They're within that category. But they find that the person is not dangerous, well, then they can be released on these supervisory conditions, right? Because they're not restorable, but they're not dangerous. So they can be released. But if they find that the person is dangerous, then they're not released. Then they continue to be held at the facility. And there's specific treatment in a situation like that that you'll see is laid out in the bill. Because you remember, that's a different universe of people. That's not the same people that were in that first 6 month, every 6 months evaluation. Because at this point, you found the person's not restorable. So kind of services they get, got to be different.
So not restorable, not dangerous, released.
Got it.
What about not restorable or restorable, not dangerous?
Well, no, restorable. Okay, so if they're restorable, they never got to this. If they're restorable, then they are continued treatment. So if they're restorable, then it's okay to keep treating them because now, as a practical matter, think about it. If they find they're restorable, and then they keep going to the forensic facility, and then they're under that 6 month cycle, right? They get in that usual 6 month cycle. I forgot, because one last little piece, just if you're not restorable and dangerous, your cycle goes to 1 year. So you're not on that 6 month cycle anymore. Then you get reevaluated every year.
If you're not restorable
and dangerous,
you're on the 1 year.
Yes, exactly. But as you said, Representative Burdett, all right, what about restorable but not dangerous? Well, that person does go to the forensic facility. They keep getting the 6 month evaluation. It's more frequent to see where they're at. You know,
So they're still held.
They are still held. You know, presumably, a person in that cycle, at some point after these 6 month, if they keep getting 6 month evaluations, which they will, at some point, someone's going to say, is this person really restorable? So someone's going to file that motion at some point in time, and they're going to end up in that other category of either not restorable, dangerous, in which case they're held, or not restorable, not dangerous, in which case they can be released on conditions.
Right, and just on that, you know, one question that's still kind of out there for the bill, I mean, there's other questions as well. It kind of came up with, and I asked Dr. Bowen from Dale, is should we somewhere have like an endpoint that it's like, I don't know, 3 years, 5 years, if you've tried for 3 years, go the other route. But that's not in here, and we want to hear from more. See if that's something that I know Matt Valerio was pushing, but
27 states have specific limit.
okay, so 27 states have a specific limit, and we can consider that still. But we have the out here, because at any time, they, like Eric said, they can ask for that evaluation. So
Right.
speculative.
And presumably, I mean, you know, that's the other thing, at least constitutionally speaking, that, you know, there's always a difference between something that's facially challenged and something that's as applied. You know, is it unconstitutional on its face in every conceivable application? I don't think so. I think in that case, you know, that sort of system does survive. It is possible that with a particular defendant, if they end up in that cycle, it keeps going and going and going, and they never ask for a restorability analysis, which seems counterintuitive, but if that happens, then it may be that, and that person would be able to show, look, it looks like I'm just in here in perpetuity and they've got no out. But that doesn't mean it would necessarily play out that way, because as the chair said, there is always this out that someone could say, this has been going on a long time. We should really look at restorability, right? And once you get into that restorability avenue, then you're either going to be held because you're dangerous or released because you're not. That kind of big picture.
The one other part that just to emphasize is that if they're dangerous and they're being held, there's also the question of whether the appropriate placement is still the forensic facility, or if there's an other option that is like less restrictive, like the least restrictive environment. So there's that separate question. If they're dangerous, it's like what level of danger does the forensic risk assessment suggest?
Right. You've got a different sort of category there. So some of the treatment approaches are a little different because they're in a different non-restorable box. You sort of got to think about it a little bit differently. Makes sense. But yeah, so that's the big picture. And that's all this highlighted yellow language, and there's a lot of detail there, but that's the attempt to create that sort of structure that I just described. So, or should we take a quick and
Coach has a question. Coach, before we get start walking through language, go ahead, Coach.
Yes. Good morning, everyone. Eric, have you started work on the categorization, that the chair brought up regarding the stages?
categorization in the sense of
3-year, 5-year, 2-year, 4-year, whatever, we're looking at to be reevaluated by the other group?
yes, the reevaluation piece of the categorization is in there, and that if you're in the standard treatment and you have not, there hasn't been a restorability question, then it's every 6 months. If it does go through restorability and you're found to be if you're found to be if your competency is not restorable and you're dangerous, then it's every year. The category that you haven't looked at yet, or at least you've talked about a little bit in conversation, but haven't decided, there's nothing in the bill on it, is should there be an endpoint? Should there be like you were saying, 3-year, 4-year, 5-year, whatever it is, should there be some maximum at which point you kind of say, at this point, we're just going to put person in maybe the non-restorability category or something like that.
Yeah, right. Exactly. That was the concern, because that's what Mr. Valerio brought up, is from the defender lane. That's a critical piece for his clients.
Right. And as I say, that part isn't in this amendment, but it's certainly something that could be easily added if the committee decides that's the direction you want to go.
Okay. Thanks, Eric.
You bet. All right. So let's start walking through the language. And I think we can move fairly quickly just because conceptually everybody understands kind of, hopefully, the language will accurately reflect what I already said the concepts were. If not, then let me know. So anyway, page 1, a couple of changes you see, really more technical, but page 1, line 11, this is, again, we're dealing with the competency group right now, not NGRI. This is the people who've been found incompetent. Now they are already within, because these persons have been charged with a crime. So there's a case pending against them that still exists. So they're not necessarily being transferred because they're not necessarily in the court's custody. It's the fact that they're just being remanded from one DOC place to another, more in all likelihood. So they're remanded to the forensic facility. That's that word change. And also looping in the qualifying condition piece. And the second change is that, if the person's held without bail, remember it's their qualifying condition that creates this risk of bodily injury. Remember, that's not just a mental illness. It could be any one of those other things. And that's the same language that's used in the NGRI. Yeah.
So in A, are they always we're assuming they're always being held prior to being remanded to the forensic facility, or might they be out on bail?
They might be out on bail. Yeah, but that would be, yes, so that would be B. It's, in all likelihood, because this is a life sentence crime only,
Got it. Okay.
probably they're going to be held, but it is possible, but most likely, in the vast majority of cases, they're going to be held.
So presumably 2B is a scenario where the weight of the evidence shows
Right.
that maybe the evidence of guilt is not as great.
Correct. Yeah, exactly. Yeah. So, all right, turning over to page 2. So now we get to the point, all right, the person gets admitted, right? They've met all the criteria, they're admitted to the facility. That's on page 2. Subsection B is about that. Remember I mentioned none of this has changed that first 7 or 8 lines or so much. This is they're subject to that 6-month reevaluation every 6 months to see if they're competent or not. And this clarifies in subdivision 2, line 8, if after one of those 6-month evaluations, the court finds a person is competent, well, then let the state's attorney know, because presumably in that case, the state's attorney might choose, all right, time to bring the criminal case forward because the person's competent now. Subdivision 3, just some language, this allowing witnesses to testify remotely. That's also that's in the NGRI section as well. It's just making sure that in both of these types of proceedings, witnesses can testify remotely. Then we move on to restorability. That's what we're talking about next. Subsection C starts on line 15. See, any party can ask that a second or subsequent evaluation include an opinion on the person's restorability, whether the person's competency can be restored. Next sentence, if someone does make that request, the forensic facility has to cause the person to be evaluated for restorability prior to the hearing. That makes sense, right? If someone's asking for that, then the evaluation should look at that specifically. Then we go on to page 3. Line 3, this is the first scenario I described. If the person so the court conducts this restorability evaluation. If the court finds that the person's competency can be restored, court shall order continued competency restoration pursuant to this section, right? So that's the route the court's looking at. All right, someone is asked to decide whether restorability can happen. Court says, yes, it can. In that case, it just goes back to this regular every 6 months evaluation track, right? But what if the court finds that subdivision 3, line 6. What happens if the court finds that the competency cannot be restored? What happens then? Well, first of all, court has to have a hearing within 60 days. All right, there's going to have to be a hearing on this, and that hearing is going to be about, remember we talked about this, dangerous. Are they dangerous? They're not restorable. I found that. So you look at line 9, page 3. Before that hearing, in other words, within that 60-day window, the court has to order a forensic risk assessment, right? So they're going to have to order that the person's dangerousness be assessed, because that's what they're going to have to decide at the hearing. And it looks at the history of line 11. Now, I should also, this forensic risk assessment isn't brand new to the bill, because there was one already that's in the NGRI part of the bill. So it's really just moved over here with one addition, line 17, page 3, the examiner's opinion as to whether the person is competent. So that's got to be included at this stage, obviously. I mean, in this evidence. So court does this assessment and look at one of the key points of that assessment, line 15, the examiner's opinion as to whether the person's release would create a substantial risk of bodily injury to another person. So dangerousness, right? Are they dangerous? It's also sort of implied there is this public safety analysis that the court's doing. Is someone going to be endangered if this person is released? So that's what the court's got to look at.
A couple questions, Coach, and then Barbara.
Yeah.
Coach, go ahead and unmute yourself.
Thank you. This brings us to the question. I think this is a good point. The witness brought us through her case, and in her case, she did ask the court to have other testimony offered in that reevaluation step. And there wasn't clarity. There was confusion with, what she was asking for. And in essence, the question never got resolved on the part of the victim, or the victim's family. And this might be the step where that can be clarified. Do you remember, Mr. Chair, that question that came up?
That was with Emily yesterday.
Yes.
Yeah, and I think that's, but the situation she was talking about was the not guilty by reason of insanity as well. And so this assessment is in that component of the bill as well.
Okay. So I just want to make sure that, or at least, ask the question that we've clearly discussed that, and hopefully um, uh, uh, the chief, when he evaluates the language too, because it seemed like there was a disconnect of some kind, and
Right.
now that's my concern.
Right, okay.
Thank you.
Bart?
So, on page 3, little
Romanet?
Romanet 4, yes. So we're just talking about bodily injury. I'm just wondering about people who are stalked or sort of emotional crimes, like serious emotional crimes that are not bodily injury. Like, is that, I don't know how often that comes up, but
I
it just,
think the cases that the case law at least really talks about bodily injury
okay.
to others. Is that, am I remembering that right?
I honestly haven't looked at that issue. I wasn't focused on that. I'm not really sure.
Sure, it might be like scaring the person quite a bit, or again, like lurking at, like,
Right.
that wouldn't necessarily be bodily injury, but there might be threat of that.
So, yeah, just the ones that I've looked at, it's talked about serious bodily injury or injury to property, but I've never seen like they, but I haven't looked at that.
Okay.
That
I
may be very difficult to capture as well. Yeah, yeah. Something to think about.
Okay.
So, Eric, proceed.
Yeah, so we were,
I think on the bottom of page 3. Yeah.
right, which was, so we just looked at what's got to be in the forensic risk assessment, and the results of all these evaluations have to be provided to the court and to the parties. That's the bottom of page 3. So, all right, so then within 60 days, right, the court has to have this hearing. This is respect to people that have been found not restorable. And then the question is, like I said earlier, is the person going to be found dangerous or not? The burden is on the state's attorney. That's top of page 4. State's attorney has to demonstrate by clear and convincing evidence that the person suffers from a qualifying condition that upon the person's release would create substantial risk of bodily injury to another person. And if that happens, if the state does demonstrate that, then you look at line 5, page 4, the court shall order continued commitment of the person consistent with the person's forensic risk assessment. So the court finds dangerousness, state's attorney carries their burden. The commitment continues consistent with whatever, remember we just looked at what's got to be in that risk assessment, consistent with what that's recommended. Then this is the piece that the chair referred to earlier. Look at that next sentence. The court shall order treatment of the person in the least restrictive setting consistent with the person's forensic risk assessment and treatment needs. So in other words, that may be the forensic facility, maybe it's some kind of outpatient treatment. Who knows what it might be, but it's got to be consistent with that risk assessment and their treatment needs. And the risk assessment, you remember, takes into account public safety by virtue of its possible impact on other people, causing harm, that sort of thing. So that's the idea there.
And just one thing, and we'll hear from probably primarily Karen Barber, but probably others as well, is that that language consistent with the person's forensic risk assessment, and that language after in the last on line 7 and 8, consistent with the person's forensic risk assessment and treatment needs, is that my understanding is the treatment is guided by that forensic risk assessment, and the treatment is more like violence prevention, risk prevention. But this captures that concept that we are no longer doing restorability treatment. It's treatment focused on that risk assessment. Is my understanding. But yeah, Ian, go.
I probably should ask this when you're doing the broad overview, but so in this section, Matt's testimony the other day, this is where he was talking about the Jackson v. Virginia case.
Yep. Indiana, but I know what you mean.
Oh, it was Indiana.
Yep.
And that like this, I think he was saying that it needs to be pretty quick in determining competency. And if you can't get to competency, then you need to move into a civil commitment because holding the individual like under the criminal docket once they've been found incompetent is unconstitutional. Or at least that's kind of how I was understanding what he was saying, but I was trying to.
There's a couple things that he missed.
That he missed. Okay.
He didn't mention the dangerousness component of Jackson v. Indiana.
Okay. I haven't read it.
And I think what this is trying to do is essentially it's largely matching the civil commitment process of Act 248.
So if there
These restrictive means with a 1-year check-in. So one of the arguments, I'm sorry, I should have Eric say this, but.
no, I'm just trying to.
One of the arguments for equal protection is that the commitment process for competency restoration is equivalent, to the civil commitment process.
Yeah.
And I think that's what we're trying to do here. That's how I've been part of reading, Jackson versus Indiana and the other.
Right.
And so
I don't think it required identical.
Not
I think
identical.
they said, hey, these are two different categories of people.
Right, but they have.
No, not. But I think you're right.
The protection argument is that, hey, I should be in the civil, I'd be treated much better in the civil process, but we're trying to have it pretty much mirrored largely.
So if it mirrors the civil process and you have that risk of harm component, then holding them in the criminal docket, even without the competency, is not going to be a constitutional.
That's the concept. And of course, Act 248 and the mental health commitment process, it all involves dangers.
Yeah.
It's so anyway,
Okay.
Sorry, Eric, didn't mean to.
No.
No,
I'll just read one quote from Jackson.
Yeah.
Without a finding of dangerousness, one committed can be only held for a reasonable period of time necessary to determine whether there is a substantial chance of his attaining the capacity to stand trial in the foreseeable future. It doesn't exactly give a lot of detail about, well, what if there is a dangerousness finding? Nevertheless, this is kind of an attempt to accommodate that.
No, that's a pretty important distinction.
Right. And it is assuming that even with the finding of dangerousness, I would think that probably unlimited, indefinite commitment without any off-ramp probably would be a due process violation. But the off-ramp is attempted to be provided, even in the dangerousness, because even then, within the dangerousness category, you get to be determined whether or not, within the non-restorability category, you have a required annual determination of whether or not you could be released or not.
Yeah.
That's the idea. And then whether that, I can't say, oh, sure, that's 100% going to survive. The challenge is going to come. And someone may say, some court may say, that doesn't do it. But I think it's an arguable and a defensible attempt to do so.
That makes a lot. That's really helpful. The only other question I had was one page back on 3. The court is being asked to make a finding that the person's competency can be restored, and there's no qualifying language there at all. Like it's likely to be restored, or it's more likely than not to be restored. I was wondering, is that too strong of language if you're going to have a battle between the state and the defense about competency restoration and the court?
Where's the line?
This is line 3 on page 3. The court finds the person's competency can be restored.
That's a good question for Jared as well.
Yeah. Maybe, or I see the point.
Yeah. Okay, that was it. Sorry to interrupt.
Is restorable. Is restorable. Maybe you still want is. Anyway, I see what you mean.
Yeah, I don't know what the right language
Right.
is.
Same
I
here.
could just see like almost every single one being, well, I can't say for certain.
Right.
Right.
It's not restored yet.
All right. So now we're continuing on. We're in this bucket of the folks who have the state's attorney demonstrated by clear and convincing evidence that a person is dangerous. Essentially, this is the non-restorable people. In that case, the court ordered the treatment that we just talked about. And if the court does order that continued treatment, I'm on line 9 and continuing down to line 12 in particular. Remember, at this point, they don't have the 6-month reevaluation anymore. Now it's every year, every 12 months. So if you're in that group, you have a longer period of time before you review. But there is always under subdivision 13, there's Roman numeral 2. if the clinical services director determines before that 12-month period, hey, actually, it looks like this person isn't dangerous anymore, well, then that person is obligated to bring the petition too. So again, if the whole idea here is to not have a in perpetuity non-reviewable status, right? So there's outs along the way. All right, but what if the state attorney does not make that showing? That starts line 17, page 4. What if they don't demonstrate by clear and convincing evidence that the person is a danger? Turn over to page 5. Well, in that case, that's when the person gets released. See? So that's the court shall, line 4, or the release of the person. And then this is not highlighted because that's language that was in the Senate passed bill as well. But so that's the situation under which release is available. So there is this out if the person isn't dangerous. That's the way, again, not clarify. It was really not too many changes to that provision, some technical things like line 9 changed to conditional supervision. So it wasn't, remember there was testimony that, is this really like an order of release that already exists elsewhere in statute? We didn't want to create that confusion. So just change the word there. So that's the bulk of the change. You can look at some of the other stuff. It's certainly some clarification, line 13, page 5, that because this says generally the person shall remain at the forensic facility. Well, as we just said, sometimes the person doesn't remain; they can be released. So that's just an exception to clarify that, so it's consistent. Some cross-reference changes because of all this redrafting. Sections changed, like page 6, line 8 and 11, because that's where this release process happens that we just talked about. And that's the fact that, and this one there, you're talking about, well, what if a person does get released? That's subsection F, page 6. Well, if they do, well, then the commissioner monitors while they're out there, and they have to, if they find out, line 12, if they have reason to believe that, in other words, they become dangerous again, right? Well, then they bring the person back to the facility. And in that case, line 15, court, they have to notify the court right away that happened, and the court has to have another hearing, because you've taken away the person's liberty again at that point. They've been released, now they're back in. You have to have a hearing, and the state's attorney has to demonstrate by clear and convincing evidence again, generally a constitutional requirement for depriving someone of their liberty, that, and there's that same standard. They have this condition and they're dangerous. So they have to, in other words, it's not just the commissioner without any objective oversight saying the person's dangerous, we got to get him back in. The court has to weigh in on that too.
So if you could also back up to page 5, line 13. I think it has to be a little broader than just C5, because there's the possibility that somebody's not restorable and needs to be held, but can be held in a at least less restrictive environment than the forensic facility. Just flagging that. I don't know exactly how to fix that, but it's not just if they're released completely. It could be.
Yeah, I see what you mean. Yeah.
Just flagging it.
Yeah, thanks.
All right.
I'm just jotting that down so I don't lose track of it. Thank you. All right. So that really brings us to the end of the competency piece. No changes to section 2. Remember, that's the section that allows dismissal of cases where a person who was found incompetent, but the case was inactive for a certain period of time. If the case is inactive for a long period of time, the state's attorney dismisses it unless the court finds that would be contrary to the interest of justice. So no changes there. Now we're moving on to the not guilty by reason of insanity piece. That's so the title of this section, lines 11 and 12, is changed to more accurately reflect what's going on. It's a person who's found not guilty by reason of insanity. We've added the provision in subdivision 2 there. Now this is bottom of page 8. This is because this came up, you may recall, because I believe it might have been Judge Zone who mentioned this, that because under this process, a court, remember, in an NGRI situation, the defense is a complete defense. So there's a question like, well, how does the court have jurisdiction over this person anymore? Because their defense was successful. There's no criminal prosecution pending anymore, as opposed to the competency piece where there's a criminal prosecution pending. That's different. And it's necessary here because the person can get released on conditions. And as I think Judge Zoney said, well, how am I going to have the authority to do that if we don't have a case? So the idea here is to make sure there is a case. And so line 19, page 8, committing court. So if they commit somebody who's not guilty by reason of insanity, they retain jurisdiction for all proceedings under this section. So they have authority to enforce orders, that kind of thing. Over on page 9. Now, remember, when someone is committed to the facility as a result of an NGRI verdict, as we just said, the criminal case, at least in the sense of the criminal charges, the court may retain jurisdiction, but they can't be punished for that criminally anymore. So the question of retaining the person, or should say committing the person in a facility against their will, is a constitutional question. And the Supreme Court has said that can be done, but procedures have to be specific. And so there has to be a hearing relatively quickly to establish that the person is dangerous and needs to be held. So that's what this hearing is, subsection B. The one change you'll see, line 2, under the Senate version, that hearing had to be within 48 hours after the person gets committed from the criminal court after being found in GRI. This gives them some more time. So let's have that first hearing within 60 days rather than 48 hours. Again, there's a forensic risk assessment that's done, line 4, because again, the key point here is the person dangerous or not? That's one of the key things to decide. Line 12, results of those evaluations get provided to the court and the parties. All right, over on to page 10, some technical corrections here. Some remote testimony language again provided under line 3, page 10. When the commissioner, so when the person is at the facility, remember their treatment is different than the competency people, because with the competency folks, that's all about restorability, right? They're trying to restore the person's competency so that they can go back to the criminal division and have their criminal case out. That's never going to happen with an NGRI case. That person was raised a complete defense. They can't charge that person again for that case. So they're not obviously not going to be restored into anything. That's not the idea. So subsection D there, line 11, page 10, that's talking about, well, what sort of treatment does the person get? And it's just adding that during the course of that treatment, the commissioner takes into account public safety as well as the least restrictive conditions and all the other elements of the treatment there. And then the way the bill had come over the Senate was that we were talking about how long between reevaluations, remember, in the competency setting, at least in that first group, it's every 6 months. And that had been the same for this group, the NGRI, every 6 months. So the proposal here is to extend that after, so it's every 6 months. It's 6 months after the first initial. So remember, that first one has to be 60 days after they get there. Then they have to have the first reevaluation within 6 months. And then look at line 3. After that one, there's a 3-year window until the next one. Line 5, after that, it's every 5 years. So the proposal is after those first 2 evaluations, the time period gets longer between each one. But there's always subdivision 4, line 7. If at any time the clinical service director says, hey, wait a second, this person actually doesn't look dangerous anymore, they also have to do it then. Do you see that? So that always kind of it sort of is in the background of all these other time periods. All right, a number of cross-reference, since this was redrafted, I had to change a lot of cross-references. We see that on page 11. Because in this case, the NGRI that we're talking about, they have something that does not exist in the competency piece, which is they can also ask for a reevaluation. And the way the language had been was basically at any time. As long as they wait until at least 90 days after their initial commitment. So rather than have that occur at any time, the proposal, page 12, very top, lines 1 and 2, is they can do it once during each of those applicable periods. So once during that 6-month period, once during I guess that would be 3 years after that, right? Yeah. So once during each one of those periods, they can also ask for a reevaluation. Clarifying the burden on line 8. Remember, it's a state's attorney that always has the burden here of demonstrating that the person's not is dangerous as a result of a qualifying condition. The rest of that is there's technical change, striking language that already appeared somewhere else. Line 11, page 13, there was a erroneous reference of preponderance of the evidence when it's always clear and convincing. And that at literally almost 10 o'clock on the button.
Very nicely done. Thank you.
Yes, absolutely.
Can we hold the question for when Eric comes back because he has to
Oh,
run
yes,
to
right.
another committee and maybe this is the question that Eric can answer or Eric will be there. And so we probably should talk as well, because I think the next version of this, we need to look at the input we've gotten with respect to victims notification and such, which we kind of put aside to get this part right first, but we're
Sure.
going to drop some additional victim notification stuff in there. But anyway, I'll let you go. I don't want you to have to run too fast to get to our friends upstairs.
At least I'm talking about the same topic, so I don't have to, as I'm walking up there, try and think, now, how do probate estates work again? Which does happen sometimes, but fortunately not right now.
Thank you.
All right, thank you, guys. Yep, any other questions, let me know.
Definitely hold that question. We'll get to it later. I just, yeah, it's. All right, Jared, let's have you weigh in on the draft. Thank you for being available and you can go ahead and proceed.
Thank you, Mr. Chair. And just again, for the record, my name is Jared Bianchi. I appreciate the work that the committee has done on this draft. We think this is a strong draft. I'll have a couple of what I call sort of fly spec edits, and then maybe some, I don't think anything terribly substantive. The big takeaway for me reviewing this draft is that there's no real red flags. A lot of these, not everything that I see in here is sort of within the range of things that the legislature has at its disposal. Just sort of walking through the bill, I won't sort of do the walkthrough like Eric just did, but I did listen in and I heard a couple of questions that I did want to address. There's a conversation about whether you need to have a statutory endpoint. I think the way that this is drafted is that that's going to be based on what the court and it's when it's doing these reviews for the competency restoration believes is sort of reasonable and appropriate based on the technical evidence that it has in front of it. Ultimately, those due process questions we would contend are best resolved by a court based on the particular facts and what is reasonable for one set of circumstances and length of time could be shorter or longer for a given defendant and presentation. So I think that here, just not having a calendar date by which a person is deemed not restorable doesn't mean that they can be treated in perpetuity, because at a certain point there's going to be a limit based on just due process grounds.
Right.
There was a question about crimes like there's a risk that somebody could stalk somebody or otherwise create a risk, and as this came over from the Senate, the federal language includes even property damage and things like that. I think that the Senate wanted to keep it to sort of interpersonal issues, so struck the property damage language from the original draft. However, I think that you could balance with relatively little editing if the committee wanted to do that by saying bodily injury or other substantial interpersonal harm. So not broadening it to things like property damage, but recognizing that a person could be a danger to another person and cause real harm without actually laying a finger on it.
So what was that again? So, or substantial interpersonal harm?
Yes, bodily injury or other substantial interpersonal harm.
Is that something that's a kind of a known definition of what interpersonal harm
Sounds
is?
social work.
I don't think so. That was what I was thinking about just as I was listening to the question. What the federal language is basically I would have to pull it up, which I can do if you'd like, but it's much more broad, so that it doesn't have just the bodily injury component. And I think consistent with what the Senate's intention was, not to have a risk that somebody is going to be just sort of generally disruptive in public being grounds to have them held, which we understand. I think that you could broaden that a bit beyond just pure bodily injury to substantial interpersonal harms and still be consistent with what their intention was.
Okay, we'll kind of look at that language, see if there's something existing somewhere that captures that.
There was a question of
So can you go to, this is kind of on page 3, what you were just talking about. We were looking at line 15, 16, but can you jump up to line 3 on page 3, the can be restored, or should we say instead is restorable?
I think is restorable would be fine. I understand the question. I think either would be fine. How's that?
Okay. Not may be restored. I think that's a little too weak. That's probably too weak.
I think then we get into yeah, I think there's got to be some definition.
Right. Okay.
Sorry, I'm just looking through my notes here. So there was a conversation about victim input at a hearing like this, and because we have moved away now from just cross-reference, that language is in the NGRI section for the supervised release, but it did not carry over here. I think that you could pretty readily put that as a Romanet number 3 on page 5, and probably it would go into line 13. So you'd have the 2 Romanets that start with order, and you do the numbering how you will, but I think that you could copy the subsection G of the NGRI language, which states that at any hearing under the section, the victim may express if it confused concerning the offense and preferences for the person's placement in care, and the court may consider the victim's testimony. That could also be placed in this section as well.
And we're also going to look at, we had some recommendations regarding victim notification that the network provided that
Right.
that also Jen Pullman agreed with, and we're going to look at that. Well,
that's wonderful. Good. Yeah, we appreciate the insight that, and again, I think I made this point before. Oftentimes, the victims that we're talking about here are family members as well, because of the way that sometimes these cases can present. So they're going to have that a depth of insight, separate and distinct even from their role as a victim, but also from their role as family. Just a text question online. Well, on page 5, where you see subsection C, it says except as provided in subdivision C5. I think you may be referring to B5. So that's just a cross-reference agreement question.
yeah, I flagged that generally for Eric to make sure we got that cross-reference right.
So I won't raise it in each instance then, because I did. There's a lot of cross-references to that section, and I think it may intend throughout to mean B5. So I'll flag that for the committee as well. On page 10, at the bottom, where you see E1A Romanet I, or 1, the state's attorney shall petition the committing court for evaluation review. I believe that was intending to strike evaluation and add review. And that would make sense.
Oh, right, okay, for review, right. Thank you.
I think, yeah, just striking evaluation and inserting review would make sense there. On the next page, page 11, under Roman numeral 2 and Roman numeral 3, I believe that there is the letter F. I believe that's supposed to say of.
Okay. Yeah, you can see that this hasn't gone through our editing yet.
No, for sure. That's, I just wanted to, you know, I wanted to flag it just because I noticed it and had the opportunity.
Yep, no, great.
And so my focus has really been sort of on the legal process questions. I don't have any input about the sections that are really much more about implementation. I agree with Eric's analysis that, there's a distinction between, what we refer to as a facial challenge and an as-applied challenge. And as a facial matter, I don't see any red flags. Certainly in the application, reasonable minds can differ, and there will be a process to address those issues if they arise and as they arise. But otherwise, with the exception of what I've said here, I don't have any additional.
Okay, so we have, Ian has a question, and then I have a question on a different section that I've been meaning to circle back around to, but go ahead, Ian.
Hey, Jared. So my question is just, so we bumped it from, so I'm on the not guilty by reason of insanity section, page 9, line 2. So we bumped it from 48 hours, which I think everyone agreed was very optimistic to have a hearing, to 60 days, which I think may have been your number. If we're talking about facial challenges, do you feel comfortable that that isn't going to be an issue like that amount of time, given the fact that we're essentially holding somebody who has been found not guilty and their case has been dismissed?
I don't have a concern. So the case law is pretty clear that in almost we would be an outlier that even has it being the state's burden at this stage to prove release after a jury has found that a person committed the charged act but was insane. Because fundamental to that is that it has been proven beyond a reasonable doubt both that the person suffers from a disorder of thought and has engaged in the charged conduct. And so in most places, the initial hearing, this is based on federal law, and the initial hearing is, I forget if it may be 45 days or something like that, but it's that person's burden at that point to prove that they should not be there. I don't, from a due process perspective, think that that's going to be a concern based on the case law that I've read, because that's just elsewhere, that would just be their first opportunity to try and gain release. They would have the burden of carrying that, though.
Yeah.
So there's a presumption that they would be in even after that.
And then I guess that was my other question was, we're making it clear that the jurisdiction is going to stick with the criminal court where the charge was pending before the verdict. Do we need to clarify that they still have access to counsel?
So my perception in this context would be that the provisions of the chapter that this would go into about a person having representation from legal aid from these proceedings would apply to this.
Okay.
I think, if Eric feels that that is not sufficiently clear, sort of, because keep in mind, we're looking at this bill, as a standalone, but this would be inserted into chapter 157, which has other provisions about representation, what the standard is for sanity, etc.
Okay. Okay, so I want to jump to actually section 6. It's not something I really asked you about when you testified before, and this is the exception from the rules of evidence, which why?
Yeah, so this is structured on, you'll see that would sit next to the language on probation hearings. And because it is operationally going to be very similar to the probation violation process, that seemed to be appropriate. I would point out that the fact that it would be treated like that does not mean that there are simply no rules. There are many court decisions that talk about what due process requires separate and apart from the rules of evidence. What that does is allow some deviations. For instance, if a critical witness may not be available for a particular hearing, or some other deviations. But there are decisions about what due process requires in any event. I would also point out that, for instance, in cases involving child safety, there are deviations from the strict adherence to the rules of evidence. And the purpose really is so that the court can consider all the available evidence and give it the weight that the court believes it deserves. It does not mean that we can simply go in and say whatever we want and that the court has no recourse. So it really means that we're taking advantage of reliable information, and the court is weighing that information on the basis of what the court can tell about its reliability. What it also means is where you have in these kinds of cases, insofar as they exist right now, in cases where you have a lot of mental health treatment, you might have a larger treatment team who is providing information to for instance, a clinical director or somebody who's in charge of treatment. And instead of having to have each person from each shift who's worked with this person come in and testify to avoid some sort of hearsay objection, basically you would have to clear out the unit to have these hearings of all of its staff if there were strict application of the rules of evidence. It would allow basically the director to testify to what the treatment team is saying. That's really the intention.
Okay. Yeah, I see. All right. Any other questions for Jared? Go ahead, Bob.
So I'm just wondering on that last point, if that can be carved out very specifically so that it's not opening up.
I guess I'm not sure what the concern is that having to do it differently would be addressing. This is already what we do for probation process. And so I'm trying to use existing structures where there is existing case law.
I mean, that makes sense from the standpoint of the clinical program director being able to say that. But I know Matt Valerio sort of raised just sort of the more blanket concern. And I guess I'd want to make sure that we weren't inadvertently waiving other rules that were an issue.
Yeah, I mean, one way that so I don't perceive that there's an issue there. I think that the general maybe perceives more of an issue there than I do based on our respective roles. There is already case law about what person subject to a judicial process can expect in terms of due process, even if the rules of evidence don't apply. However, there is language, for instance, in Title 33 that simply states that the court may take into consideration reliable hearsay. That's not a verbatim, but something to that effect, essentially. So this is basically for certain components of Chin's hearings, for instance, there's just a carve out for hearsay. That's another way to do it. I think either one would be acceptable. I think the benefit of doing it this way is both that we have the benefit of the due process guidance from the courts already, but also that because these are hearings that are really intended to protect the public while providing the person a process, strict application of the rules of, for instance, having to go through the process of, laying a deep foundation for a video and calling certain custodians of records. It's really stuff like that is perhaps not as necessary for these types of hearings. But there will be core determinations of, opportunities for instance, for the person to call their own witnesses, et cetera, that would still be in place. Some of those core due process functions.
All right. Any other questions for Jared? Not seeing any. Thank you very much. And like I mentioned to Eric, that we are going to look at the language related to victim notification and such. So that will be another draft and some tweaks that we have so far. And then we're also still have a few additional witnesses, obviously, on this draft that we will probably not get to until Wednesday of next week, Wednesday morning. All right. So we'll go with, to Judge Zoney next.
Thank you, Mr. Chair and members.
Thank you.
Good morning.
Good morning. Good morning.
I'm Zone, Chief Superior Judge. When I received the version, draft number 1.1, my focus really was trying to look at, for the most part, the yellow highlighted language for changes to talk about that today. And on page 1, line 11, there was a change made. It says a person shall be remanded to the forensic facility. The individual would need to be remanded to a person, in other words, or an entity, to the Commissioner, Department of Corrections, or Commissioner, Department of Mental Health. There needs to be someone in charge. And so I think that has to be changed. We just don't remand someone to the facility. We remand someone to put them in the facility.
Right. Okay. So we'll have to hear from folks on who that is. Is it the Commissioner of the Department of Corrections, or is it elsewhere we use the Forensic Facility Clinical Services Director? So that'll be a question that we'll resolve. Okay.
page 2, line 8, it says if the court finds after an evaluation that the person is competent to stand trial, the court shall immediately notify the state's attorney and the person's counsel in the criminal case. This doesn't, it's not clear what this really intends to do, because there needs to be a hearing to find something. And presumably the state's attorney and the defense attorney and would be part of that hearing. So it doesn't make sense why the court would be notifying them of some finding. Is
Yeah,
there
no, that makes sense. I had flagged that on a version. I had forgotten to talk to Eric about that exact point, that it doesn't, that they presumably are there at the hearing.
Yes. So, and this is unclear whether it's something outside, but you understand there's an issue there that it seems like this is starting something that doesn't flow with the process. Line on page 3, there is a provision that allows witnesses to provide testimony remotely. Legislature has done that in other areas. Civil DUI was one that comes to mind. There are sometimes questions that can be raised relative to confrontation rights, and the courts would certainly have to address that in the event that happens. There's also a question that could be raised as to whether specific findings have to be made by the court to allow the remote testimony. However, again, I understand the legislature has done that as a policy, and if it has a policy that goes forward, the courts will have to address that. I just wanted to flag that there may be some issues. On page 3, line 3, again, this goes back to what we were just talking about at Chair Lalonde. Where's the finding coming from? Was there a hearing? How do we handle that? Page 3, line 9 talks about a forensic risk assessment. There's no guidance as to who conducts the forensic risk assessment. Is it like a risk assessment that we use in Act 248 proceedings that may involve sex offenders, or is it a DOC high risk offender committee? So we don't know who's supposed to provide this report. That should be clarified.
Okay, and before you go forward, I want to go back to your previous point on I guess on line 3. I want to make sure I understand. Presumably, let's see. At the request of the party, the court may order the second or subsequent competency. So I'm looking at C1A, asking, that the party has requested this hearing, and presumably they're going to be presenting the evidence regarding restorability, which is on line 18 to 20 for the hearing. And that's the hearing, and that's what that C2 is based on, isn't it? I'm just trying to make sure I'm following the concern.
My quick read of this, I think that if you go back to line 8 on page 2, that is where some confusion, at least in my mind, comes from, because it talks about the court making a finding. And so that's the confusion that I have, is this talks about the court making some kind of finding. We don't know where or how the court makes that finding to have this notice. And then it jumps right into a second competency evaluation. Well, is that after the finding or before the finding that we're going to order the second competency evaluation? And then on line 15, that subsection on page 2, that talks about there's another competence, line 19, competence prior to the hearing. What hearing? We haven't set the table, as far as I can tell, for the hearing that's going to come up at this stage in the bill. And then we go to page 3, and it says on line 3, if the court finds that there can be restored, the court shall order. But we still haven't talked about the hearing.
All right, so subsection B, we need to clarify that. I mean, it's saying cause a person to be evaluated for competency to stand trial, right? And we need to put in there making clear that this is going to be then before a court in a hearing for the court ultimately decide that. So I see in that one, definitely need that. Is that
My
right?
suggestion would be if you can, I would say almost chronologically, I think it's much simpler for everyone, the litigants, the judges, if it says if you look on page 2, upon admission, and then it talks about what happens. And then what is the next step in the process that the legislature wants to adopt as far as a policy? Is the next step that there's going to be a hearing? Okay, then we set forth there's going to be a hearing. But if before the hearing, if there's going to be evaluations, that should come before the hearing. And so I would structure the statute in a way that takes it step by step. You go from A to B to C to D and just lead you through.
Yeah, and that's what this draft does relative to the as passed the Senate, but apparently we need to continue to work on that a little bit more to make it even clearer. So, okay.
Page 9. This is where it talks about, actually page 8 and 9, section 3 talks about not guilty by reason of insanity. On page 8, bottom sections, lines 19 and 20, it says the committing court shall retain jurisdiction over the person for all proceedings under this subject. So it would appear that the intent is the criminal division. But the language there's a section that talks about providing on page 9, line 12, the results of all evaluations shall be supplied to the court and the parties to the underlying criminal action. Well, you're already in that court. In other words, it is the case. So there's some confusion as to why would you need to put it to the underlying criminal action because you're in the underlying criminal action. It's the same case.
Right. So in other words, we just don't need the language to the underlying criminal action or the whole thing?
I would agree. I think just if you get rid of that language, it removes that potential issue.
Okay.
And on page 18, section 6, I'll go back to a question that you had, Chair Lalonde, and that was about the Vermont Rules of Evidence, and that is a policy decision for the legislature. The question you have to ask is, do we want to have it more? I think Mr. Bianchi was talking about this provision, the way it's in there, would be more in line with the violations of probation cases. The question for the legislature is, do you want to be in line with VOPs, or do you want to be in line with the existing mental health statutes that you're currently have been utilizing for mental health when it goes from the criminal division and moves over to the family division? For instance, under 18 VSA section 7615, it specifically says that the rules of evidence apply in involuntary commitment proceedings. And so that is a basic policy question for the legislature. Which direction do you want to go in?
Right. Yes, that's been kind of an overarching one on this whole thing. So, okay. Any questions for Judge Sone?
Bless you.
So the one thing is, I might have Eric reach out to you to make sure that, you know, when he's drafted, since he can't be here right now, to make sure we understand for that on page 2 and 3, making that very clear, if that's okay.
Absolutely. My pleasure.
Okay. Yeah. All right. Any other questions for the judge? All right, not seeing any. Kim, did you want to weigh in too? Or you're good? Anybody else? Claire, you're good as well? All right, so we
Mr.
are.
Chair?
Yes, sir.
You weighed in.
Yes, yeah, go ahead, Coach.
Thank you. Judge Zone.
He just logged, he just left the Zoom room.
Oh, okay. I'll catch up with him.
Yeah, you'll need to touch base with him. So I'm assuming tomorrow we're gonna be on the floor into the afternoon. So I'm just gonna call off we were gonna have Karen Barber in tomorrow afternoon, but I'm just gonna have her next week. So that's all good for everybody. All right, so we are adjourned until